Hi, good day. My name is Micah Urandi. I work with California Indian Legal Services, and I'm a staff attorney in our Escondido office. I'm also a member of the Navajo Nation, and today I'm going to be presenting on this pre-recorded session for ICWA 101, just the basics of the Indian Child Welfare Act. And this is part of the 27th annual statewide ICWA conference, which is going on now, June 24th to the 25th. The live sessions will be available via Zoom link, and this is the only session that has been pre-recorded and will be available outside the live recording schedule time. Unfortunately, since this is pre-recorded, there will be no questions, but at the end, you'll have my contact information, and feel free to reach out to me if you have any specific questions. So let's jump right in. So today what we'll be covering is the California Indian history, the effects of removal, especially relating to the California Indians from their territorial lands, the role of the Indian Child Welfare Act, the implementation of the Indian Child Welfare Act's key provisions in state court proceedings, and we'll follow it through a state court dependency process from start to finish. California Indians, a lot of the information that we have is kind of guesswork. The estimated population of California Indians pre-contact, this is before any European contact, whether it be Spanish, Mexican, Russian, or any American contact, the estimated population was to be about 300,000. Again, this is just the estimated population. At the time, pre-contact, there was estimated to be over 100 tribal groups that were living in California. And of the 100 tribal groups, there were probably 500 different bands. There were more than 8 different language families that were spoken in the California region. And the California region definitely had significant diversity between the groups. Not all the groups shared the same language or even traditions or values, but they were all very significantly different and had distinct populations that, when thinking about California Indians, should be recognized and remembered. Post-contact, and this is with, again, contact from the Spanish, Russians, and Americans that had contact with them. Conservative estimates suggest that about 80 to 90% of the California Indian population hit a significant decline after the influx of the European settlers. A lot of the contact and a lot of the decline in the population occurred either through theft or removal of people from their lands, of native peoples from their lands. And the theft of land most frequently occurred through, or is most commonly recognized through, the unratified treaties. There were also forced removals. Just the California Indians were forced to be removed from their lands and relocated to new areas. There's a really good infographic on the LA Times that shows kind of the relocation of the Los Angeles Valley area natives, and kind of how their different villages were disintegrated by these relocations by the Spanish missions. Post-contact, a lot of the population declined as well due to assimilation policies, and we'll talk a little bit more about that, and boarding schools. But most of the post-contact with Europeans had a lot of effects on the Native American population in California in general. So oftentimes when growing up in California, you do learn a lot about the California history. We learned that in 1542, the first explorer lands in California. By 1969, Southern California has been settled by the Spanish, and by 1812, the first Russians have arrived in Sonoma County. So we get like this nice glossy history of California. We get the pictures of the first Catholic mission in San Diego, and you know, it's all about a great rise for populating and making California a thriving place. But oftentimes what is ignored is the fact that there were already Native Americans, California natives, living in the area, and when these settlers first arrived, they ended up pushing a lot of the natives out of their lands. So again, pre-contact estimates had about 300,000 people, 300,000 California Indians living in California. By 1849, in 1848 to 1849, the estimated Indian population was about 125,000. So more than half had already been lost in that short time from contact to 1848. And with the rise of the California gold rush, many settlers and prospectors were coming to California, with an estimated 40,000 settlers and prospectors alone arriving in California. There were huge notices that were sent out saying, gold rush, Indian territory, come claim your home. And this, again, caused the problem for a lot of California natives who were living in this area and were, again, being displaced by the different types of populations. By 1850, California had been admitted as a state. From 1851 to 1852, there were about 18 treaties that were negotiated for a total of 8.5 million acres reserved. 8.5 million acres of California land reserved for Native Americans, for the California natives who had been displaced. From 1880s onward, the state had pressured the Senate not to ratify these treaties. So during the short time when all of these treaties had been negotiated, there had been pressure by California to say that we don't want these, this is going to intrude on our growth and our development, and the Senate did not ratify the treaties. These treaties, in fact, remained hidden until about the early 1900s, and there was huge pressure to restore some lands to the natives, but at that point, there was no way of recovering the original 8.5 million acres. Roughly around this time, there was an effort to educate the Indians as part of assimilation policies, and there were 23 Bureau of Indian Education schools, Indian schools that were in place to do this education and assimilation. In California, some of the famous ones and more commonly were the Sherman Indian School, St. Boniface Indian School, and the Fort Goodwill Indian Boarding School. So a lot of times these locations not only included California Indians, but also Indians from other states as well, as an effort to hopefully assimilate them and get them away from their own cultural lands and cultural values and basically forget them and become westernized. This is a common picture that is shown to depict what the Indian School Project was and the key results and what the schooling program was intended to do. On this side, the black and white is a group of Indians that were brought in to the Carlisle Indian School. And this is actually in Pennsylvania, so these are more famous for that area. But these Native American students were placed in school, and it makes it seem like they were not as clean, not as healthy, and then you have this next picture next to compare all of the children. And they're cleaned, they're dressed in like uniform, and they definitely look like they are have improved. And that's the whole point of the Indian School Project, was to make it look like there were big benefits to the school, and that the schools were doing great things for the children. So oftentimes people forget that Indian tribes are in existence. They don't really know a lot about who the Indian tribes are, where they're coming from, or how many there are in existence. In the United States, there are 574 federally recognized Indian tribes, and there have been some more discussions about state recognized tribes. This is the only number that we will be talking about today, though, is federally recognized tribes, unfortunately, because every state has a different process for recognizing tribes that aren't federally recognized, but in terms of the Federal Indian Child Welfare Act, that relates to federally recognized tribes. So again, there are 574 throughout the United States, and more than 230 of these are Alaska Native groups. Some of the states with the largest Native American populations include New Mexico, Arizona, and Oklahoma. Tribal sovereignty is one of those key things that definitely needs to be discussed and understood a little bit more when thinking about the Indian Child Welfare Act. Under tribal sovereignty principles, every tribe has the ability to regulate their internal affairs and domestic relations and enforce their own laws in their own forms. And this comes from a United States Supreme Court case, Santa Clara Pueblo v. Martinez. So inherent in tribal sovereignty is the power to make and enforce laws, regulate domestic relationships, and ultimately to determine membership. Focusing more specifically on California Indians, there are 109 federally recognized tribes in California. There are approximately 78 tribes petitioning for recognition with the Bureau of Indian Affairs, and approximately 20 tribes are in existence in the Southern California region, which is where my office is. And this map does a good job of kind of showing where a lot of the tribes are located. So here we have some along the state line, further down, and there's just this huge gap in LA, Santa Barbara, San Bernardino, Kern County, and then we start picking up more as we continue going up north. When thinking about tribal land or tribes, it's important to understand the term reservations. Not every tribe has a reservation. Not every tribe has their own land areas. Some tribes are landless, but reservations are of all different sizes. And right now there are about 278 Indian land areas administered as reservations. There are 110 reservations or rancherias in California. So again, when we were talking about the number of federally recognized tribes in California, there were 109. So there is 110 reservations. And the reservation sizes range from 16 million acres. So this is just across the United States. The largest land reservation is 16 million acres, which is the Navajo. And the smallest area is the Jamul Band in San Diego County. So you'll see their little red on the corner here. And then there are countless tribes that are considered landless and don't have their own reservations. So again, there are 278 Indian land areas administered as reservations. And there are 574 tribes, federally recognized tribes. So over approximately half of those federally recognized tribes don't have their own land or reservations. So why is the Indian Child Welfare Act important? Since 1854, Indian children were being removed from their homes due to poverty, illiteracy, failure to assimilate, or lack of spiritual structure. A lot of these don't necessarily rise up to the neglect or abuse standards. A lot of it was just that people could not stand seeing the poverty and the failure to assimilate and thought that that wasn't being a good parent. So many children were being removed from their homes to facilitate assimilation procedures or assimilation policies. In 1971, the BIA estimated that there were about 35,000 Indian children in the United States who were in boarding schools or placed away from their families. And during the congressional testimony, the senator from South Dakota had testified that 25% of all Indian children were either in foster care, adoptive homes, or in boarding schools. So that was a huge population from South Dakota that weren't being accounted for in their own natural homes, but were in some sort of adoptive or other kind of living arrangement. There have been a lot of studies on the effects of removal and what it means and how it has affected Indian children and Indian children when they become adults. Placing Indian children in non-Indian foster homes or adoptive homes does put them at risk for experiencing greater psychological harm or trauma, leading to long-term emotional and psychological problems. Most people, especially in the dependency world, are aware of ACEs, the adverse childhood experiences, and we understand how these adverse childhood experiences can have effects on a person in their adulthood, oftentimes causing more future healthcare problems that if the trauma had been avoided or had been handled appropriately, could address some of these healthcare problems down the road. So it is very important to be thinking about how, whenever Indian children are removed from their homes, how to keep them in culturally appropriate and culturally relevant homes. Some of the key problems with the effects of removing from Indian homes is that an Indian person will lose their identity, family, tribal affiliation, and oftentimes there is a failure to recognize the differences between white and tribal cultures. A lot of children who were removed from their homes and placed with non-Indian families often grow up feeling a sense of being different, but not being able to fully understand why. In fact, one of the studies that had gone through this was a study by Carol Locust, Cherokee PhD. She coined the term split feather syndrome. Basically, under the split feather syndrome, Indians who are placed with or adopted by non-Indians identified with the split feather syndrome, which includes the loss of Indian identity, the loss of their family, cultural heritage, language, spiritual beliefs, tribal affiliations, and tribal ceremonial experiences. Experiences were different when they were growing up in their non-Indian homes. They weren't able to experience traditional and cultural events that was normal for, or that was common for other Indians of their age in Indian homes. A lot of them also experienced discrimination, and there was a conflict in their learning styles. Oftentimes children who come from Indian homes have a different type of learning style, and that was not being replicated or taken into consideration when they were placed in non-Indian homes. There was a compilation of Native American stories for Native American adoptees who were placed with non-Indians, and some of the stories and some of the quotes are here above or included on this slide. One adoptee stated that adoption causes such intense inner pain that you do anything just to get away from it. No one understands you, you are different, and there's no one to talk to. You withdraw into yourself, keep it all inside. That's how I got into trouble with alcohol. It was pain medicine. Another Indian adoptee reported, my foster mother was very abusive. She always said we were dirty because we were dark. She beat us often, made our noses bleed. But the worst thing she did was denying us our Indian heritage. Courts should never let anything like this happen. Indian children need to be with Indian families, not white families that are so different from Indian. So when examining what was going on with this large-scale removal of Indian children from Indian homes, a congressional team was set up in the 1970s to kind of look more closely at this event and what was going on. In the congressional findings for the Indian Child Welfare Act, Congress determined that there is no resource more vital to the continued existence and integrity of Indian tribes than their children. Removal requires a response from the United States government because there is a special relationship between the United States government and Indian tribes and their members. Additionally, the United States has a responsibility to protect Indian children who are members or are eligible for membership with an Indian tribe. There was also finding that an alarmingly high rate or high percentage of such children were placed in non-Indian foster and adoptive homes and institutions, frequently suffered serious adjustment problems during their adolescence. Also, during this time of congressional findings, there was testimony presented to Congress by the chief of the Mississippi Choctaw, Chief Calvin Isaac, and he stated that culturally, the changes of Indian survival are significantly reduced if our children, the only real means for the transmission of the tribal heritage, are to be raised in non-Indian homes and denied exposure of their people. Furthermore, these practices seriously undercut the tribe's ability to continue as self-governing communities. Probably in no area is it more important that tribal sovereignty be respected than in an area as socially and culturally determinative as family relationships. So from all of this testimony, all of this investigation, and looking further into why so many Indian children were being removed from their homes, the ICWA was created, and the role of the ICWA, the Indian Child Welfare Act, was to promote the best interests of Indian children, to promote stability and security of Indian children and their families, Indian tribes and their families. How did it expect to accomplish this? Well, it set about creating some minimum federal standards for removal and placement, which reflect the unique values and cultures of Indian tribes. Important in this was that tribes were to be assist in the operation of child and family service programs and to be involved in cases that involve their Indian children. So oftentimes when people think about the Indian Child Welfare Act, there are a lot of myths that are going out about there. One of the myths is that the ICWA applies to all children who identify as Native American. This is false. The Indian Child Welfare Act covers any child who is either a member of a federally recognized tribe, an Alaska Native village, or is a member, is eligible for membership in the federally recognized tribe or Alaska Native village, and is the biological member of a federally recognized tribe or Alaska Native village. So it's not just enough that a person identify or a child identify as Native American. This criteria must be met, that the child is either a member or is eligible for membership and a biological child of a member. A second myth is that the Indian Child Welfare Act favors Indian family members over non-Indian family members. This gets heard a lot, and it just keeps going on and saying that people will often say that, why does an Indian family get a preference over the non-Indian family? That's not what the Indian Child Welfare Act does. Nowhere in the Indian Child Welfare Act does it indicate a placement preference for a Native or an Indian relative over placement with a non-Native or a non-Indian relative. All that matters is that there is a relative that is eligible for placement for the child. Down below, we have a little link to the National Indian Child Welfare Act, National Indian Child Welfare Association. If you want more information on these myths, you can go to this link down below for more information. So here are two more myths that we'll talk about briefly. Myth number 3, the Indian Child Welfare Act only requires efforts to protect Indian children after they are removed from their home. Nope, the Indian Child Welfare Act requires what's called active efforts. That means that the state must work closely with the family to ensure they receive any services necessary before a child is removed to prevent removal from the home. Another myth is that the ICWA is a race-based law. The ICWA is not a race-based law, contrary to common belief. The ICWA, like other federal Indian legislation, is based on the unique political status of tribes and Indian people and is not based off of their race. This unique political status has been established by Congress, the Constitution, statutes, and treaties, and has been affirmed and reaffirmed in U.S. Supreme Court decisions for over 200 years. And again, we have a link to the ICWA page for more information on these myths. Okay, so jumping into the ICWA definitions, we talked briefly about when the ICWA applies when there is an Indian child. Again, an Indian child is an unmarried minor that is either a member of a tribe or is eligible for membership, and the biological child of an enrolled of a member. And you saw me there. I took back a little bit about that enrolled member because, again, enrollment is not necessarily a prerequisite for membership. Many tribal members will not have a membership card or proof that they are Indian, but they are still considered members of their tribe. A parent is any biological parent or parents of an Indian child or any Indian person who has lawfully adopted an Indian child, including adoptions under tribal law or custom. It does not include the unwed father where paternity has not been acknowledged or established. The parent, to be the parent of an Indian child, they do not need to be Indian. The ICWA does create this other classification called an Indian custodian. An Indian custodian is any person who has legal custody of an Indian child, whether that custody has been bestowed upon this person through tribal law or tribal custom, through state law, such as a guardianship or adoption, or by any Indian person to whom temporarily physical custody, care, and control has been transferred by the parents. Indian custodians have the same rights as an Indian parent under the ICWA. And this is very important because sometimes people, when children are being removed, when Indian children are being removed from a home, oftentimes it's just a look at whether there is more often than not, the parents are immediately listed, but there should always be a determination or there should always be an analysis to determine whether or not there is an Indian custodian involved, because it could just be an Indian person who the parent has transferred temporary custody, care, and control of their child over to. So always look out for that. Some other ICWA definitions that are defined in the ICWA are an Indian tribe. Again, this is an Indian tribe only pertains to federally recognized tribes. So those are any tribes, bands, nations, or any other organized group or community of Indians recognized as eligible for services provided by the Bureau of Indian Affairs or the Department of Interior due to their status as Indians. California does have a state bill or a state law, SB 678, that does allow participation by non-federally recognized tribes in dependency court cases, and it is at the court's discretion to allow the tribe to be involved. So you can check out that specific provision for more information. Tribal membership, again, as we talked about briefly in sovereignty and what sovereignty means, tribes do have the ability to determine their own membership criteria and eligibility, and it is in the tribe's determination to make the conclusive determination as to whether or not a person is an Indian member or a member of their tribe or not. Without determination of a tribe, the BIA determination is also conclusive. So if a tribe just doesn't respond, but the BIA does have records that this person is a member or an Indian member, that determination is conclusive that they are eligible. Absent tribal or BIA termination, the juvenile court will determine whether the ICWA applies. And ultimately, though, the Department of Public Services, DPSS, and probation cannot determine, or DCSS, or whoever the social services program is, the county, they are not the ones who are able to determine whether or not the ICWA applies. Indian child custody proceedings. This is a term that has been highlighted in the Indian Child Welfare Act. A child custody proceeding is specific and has a specific meaning in the ICWA, but it does relate to any time that there is a foster care placement of an Indian child. So foster care placement involves removing a child from a parent or Indian custodian for temporary placement in a foster home or institution, guardianship or conservatorship, when a parent or an Indian custodian cannot have the child returned upon demand, and when the parental rights have not been terminated. So those are all required to make a determination of a foster care placement. Some other specific child custody proceedings as defined in the ICWA are termination of parental rights proceedings, pre-adoptive placement proceedings, adoptive placement proceedings, and probate guardianships. So now we'll get into the implementation of the ICWA. So this is a quick overview. The steps of the implementation. Again, the Indian Child Welfare Act sets out minimum federal standards. And these minimum federal standards include inquiry, notice, removal, intervention, right to counsel, access to records, services, specifically active efforts. There is evidentiary burdens of an expert witness and placement preferences. So pre-removal inquiry is required. There must be a determination that there is a reason to if there's reason to believe that what's going on? Okay, so moving on to pre-removal. The Indian Child Welfare Act has requirements that a social services agency conduct an inquiry as to whether or not there is an Indian child involved. This has been codified in Welfare and Institutions Code section 224.2e. If the court, social worker, or probation officer has reason to believe that an Indian child is involved in the proceeding, the court, social worker, or probation officer shall make further inquiry regarding the possible Indian status of the child and shall make inquiry as soon as practicable. If there is an Indian child involved, or if there's reason to know that there's an Indian child involved, the social services department must make a showing that active efforts has been provided to the parents to prevent the breakup of an Indian family. They must show that they have provided remedial services and rehabilitative programs designed to prevent the breakup. California case has talked a little bit about this and stated that the steps must be timely and affirmative. Moving on to detention. At detention, there is a requirement that inquiry be conducted again. So when the case starts and there is an investigation going on, that's the pre-removal stage where inquiry must be conducted. But once this comes before the court, there is that extra step and that additional step that inquiry must be conducted. The inquiry is often conducted through the forms 020 and 030 forms. These are the state or judicial council mandatory forms that are prepared. But basically, it just helps the court to talk to the parents and determine whether or not there is an Indian child involved, or if the parents have any Indian heritage as well. And again, this is an ongoing process. So if a parent has no information or does not have further information on it, if at the detention hearing the court finds that the ICWA doesn't apply, but later on down the road there is new information that the child may be an Indian child, this must be brought up again. It must be brought before the court's attention as inquiry is an ongoing process. If there is a finding, or if there is some information that has been provided by the parents that there are tribes that might be involved, or that the child may be a member of a specific tribe, notice must be sent to all the tribes which the child may be a member of or may be eligible for membership with. So for example, If there is evidence that a child is Cheyenne, both the Northern Cheyenne in Montana and the Cheyenne Arapaho in Oklahoma, these two tribes must be noticed. Tribal notice should be sent to the tribal chairperson unless there is a specific agent designated for service, which is in the BIA's ICWA designated agents form as well. If the identity or location of a parent or Indian custodian or tribe cannot be determined, then notice must be sent to the BIA. And in California, this would be sent to the Sacramento office. The BIA has 15 days to provide notice as required by law, and a copy of the notice must be sent to the BIA even when the identity of parent, Indian custodian, and the tribes are known. Also allowed and discussed in the Indian Child Welfare Act is the tribe's right to intervene. There seems to be a lot of confusion as to what intervention means. Oftentimes people think that when a tribe is intervening, it means they are taking the case out of state court and transferring it. That is not what intervention is. Intervention can be, intervention is just the tribe saying that we are going to be involved in this state court case. There are specific citations here to 25 USC 1912A and the Welfare and Institution Codes and the California Rules of Court regarding intervention. But basically, an Indian custodian and an Indian tribe have a right to intervene at any point in the proceedings. It is really hard because sometimes tribes don't have all of the ability to be involved in every single case involving their Indian children. Some may choose to intervene and be very involved from the get-go and participate in child family team meetings. They may be involved in helping prepare the case plan. Some tribes, they just don't have the ability to meet all of these requirements, or not requirements, they don't have the ability or the time to extend to all of these different events that are going on, and might just play a minimal role requesting updates from the social worker as to what's going on with the family, the child, and what's happening in the case aspect of it. So intervention can look different for different tribes. Some may appear by their council, or some may appear by another designated representative. Others may send their tribal social workers to intervene and participate in the court proceedings. Intervention can occur orally or written. And sorry, I have this judicial council form. It was 040. This form used to exist and it no longer does, so please disregard that. This used to be a form that allowed a party to intervene, do the written intervention using a judicial council form, and this form is no longer available. If a tribe doesn't intervene, the court may still permit participation in proceedings under California Rules of Court 5.5 through 4.1.2 or I2. Even if a tribe, and this is really important, sometimes tribes just don't have the resources to participate in all cases involving their Indian children. And just because a tribe does not intervene in a case, even if it's just saying that they want to be notified or participate or hear what's going on in the case, even if they just don't respond, if a tribe doesn't respond, but there is information that the child is a member or eligible for membership, the Indian Child Welfare Act must still be followed, and the act still applies in the case. Transfer. So going on to the topic of transfer, like I said before, oftentimes people confuse intervention and transfer. Transfer is specifically relating to a tribe asking the court, the state court, to relinquish jurisdiction and transfer the case to tribal court. Transfers are not granted as a matter of right. The transfers can be denied by a state court if one or both parents object, if a child is over the age of 12 and they object, if the tribe denies transfer, the tribe doesn't have a tribal court to handle it, or there is good cause such as hardship. But this good cause exception, it shouldn't be used often, and it is rarely used often. The first four are more specifically relating to mandatory non-transfers, and the good cause is more of a discretionary transfer denial. So why would a tribe deny the transfer, or the tribe say that they don't have a tribal court to handle it? Sometimes it's a matter of a parent petitioning to have the case transferred to tribal court. Sometimes it might be a child who's petitioning to have it transferred to tribal court. The transfer doesn't need to be started by the tribe in order for it to get transferred over to state or tribal court. It can be conducted by any of the parties. So just a reminder about that. Another thing that the Indian Child Welfare Act does authorize and has been codified in California law is for tribes to have access to records. There have been a lot of fights in the past about whether or not tribes have access to the reports and other information that the county provides to other parties, like the parents or the minors in the case. But under Welfare and Institutions Code 827, tribes do have access to these records. Each party has a right to examine all reports and other documents filed with the courts. So this includes the Indian custodian and the tribes as parties if they decide to intervene. And tribes have a right to disclosure and discovery, the exchange of legal information, and other known facts. So this is very important for tribes to know and have access to. Okay, so moving on to the jurisdiction and disposition hearings. There is a requirement that there must be a finding of detriment. This means that there must be a finding by the court that foster care placement is necessary, because no foster care placement can occur absent clear and convincing evidence that continued custody will likely result in serious emotional or physical injury or damage to the child. Similarly, there can be no termination of parental rights absent evidence beyond a reasonable doubt that continued custody would likely result in serious emotional or physical damage. Either of these findings, these detriment findings, must be supported by testimony of a qualified expert witness. And sometimes tribes will provide their own qualified expert witnesses. Other tribes prefer not to. So always communicate with the tribe to find out whether or not the tribe wishes to provide their own qualified expert witness or not. The failure to meet non-Indian family and child rearing community standards may not be considered for removal. So there must be a showing that just because a family is not adhering to Western values or Western cultural community standards, that is not enough of a basis to remove. An improper removal will result in immediate return of the child to a parent or Indian custodian, unless that return will result in substantial and immediate danger to the child. So going back to the expert witness evidentiary burden, the expert witness will have to testify as to whether or not continued custody of the child by the parent or Indian custodian is likely to cause the Indian child serious emotional or physical damage. The expert must provide oral testimony unless all parties agree in writing. And most importantly, the expert cannot be an employee of the Child Welfare Services Department or agency. This must be someone who is independent and someone who has knowledge on the cultural practices of the tribe as well. Other requirements of the ICWA that come into play, and technically this does happen and comes into play as early as detention as well, but the placement preferences. Before we talked a little bit about child custody proceedings, and the placement preferences also kind of follow that. So in any foster care or pre-adoptive placement, it is a standard, or there is an order of preferences that must be followed. First of all, the placement must be the least restrictive setting, which approximates a family situation, and shall be within reasonable proximity to the child's home. And the preferences are in the following order: a member of the extended family. So again, going back to those myths, this doesn't say a member of the extended Indian family. This is just a member of the child's extended family. Foster home approved by the tribe. An Indian foster home, this can just be any Native American family that has gone through whether the county or private foster family agency organization, and has become a foster home, licensed foster home through them, but they happen to be Native American. That would be the Indian foster home. Or an institution approved by a tribe or operated by an Indian organization. And there are some group homes. When I worked in Arizona, there were some tribes there that had their own group homes that were operated by the tribe. So this would be one of those situations where it would be an institution approved by the tribe or operated by an Indian organization. Again, Indian means a member of a federally recognized tribe under the Indian Child Welfare Act. Okay, moving on to review hearings. At the review hearing setting, there are requirements of active efforts or active services. Where the Welfare and Institution Code calls for reasonable efforts for non-Indian families, under the ICWA for Indian families, there must be a finding of active efforts. What are active efforts? So this is confusing because there is some case law that exists that some places still rely on that state that active efforts are reasonable efforts. This is not true. Active efforts are beyond the passive services normally provided in reasonable services. We'll go through and look at some specific examples provided in the code, but these just cannot be giving somebody a referral list. It's more like you give them a referral list, and if a parent doesn't have the ability to make the calls on their own, the department would be involved to remove those barriers for this parent to access these services for referral, or these referrals and so forth. The efforts should also take into account the prevailing cultural and social conditions of the tribe. The efforts are also to be culturally appropriate and not tainted by cultural bias. And again, active efforts apply at the pre-removal settings, making sure that there were efforts provided to prevent the breakup of the Indian family, and that there must be a finding that such efforts were unsuccessful to keep the family together. Okay, as I stated, there are some examples of active efforts that are provided for in California law, and this has been codified at Welfare and Institutions Code 224.1F. This is just a synopsis, or like shortened. If you want to read more a little bit about it, these sections have more detailed information of what the active efforts examples are. But again, there must be a effort to conduct a comprehensive assessment of the family and determine what services would help and benefit the family, identifying appropriate services and helping the parents overcome those barriers. So again, going back to the referral list, instead of just giving the parent a referral list, asking them, why aren't you making this call? Like, how can I help you? So actively assisting the parents in obtaining those services. Inviting tribal representatives to the table, whether it's in helping prepare the case plan, or attending the child family team meetings, or just notifying what's going on with the family and seeing if the tribe can help out in any way. Those are more examples of active efforts. Conducting diligent searches for extended family members. As we talked about before in the removals and the assimilation, a lot of times Native families might not fully know who their extended family members are. they might know who their mom and dad is, and that's it. They might not have a close enough relationship with aunts, uncles, or grandparents even. So just kind of like working with them because of all of these removals and assimilation efforts. Some people were flung far and wide and super far away from their families and haven't had the ability to get back to where they were. Some of them might have been even the product of the initial, what brought about the Indian Child Welfare Act, and they might have been Indian adoptees as well, so they don't fully know who their extended family members are. So working with the tribe or working with the individual members and kind of talking to them and talking with the families to flesh out who their extended family members are and trying to find ways to reach out to them. Those are more efforts. Those are more showing of active efforts. Also, just culturally appropriate family preservation strategies and services. Keeping siblings together whenever possible, supporting regular visits between the children, their parents, and their community and their tribes, identifying community resources and actively assisting the Indian child's parents, or when appropriate, the child's family, and utilizing and accessing those resources, monitoring progress and participation in services, considering the alternative ways to address the needs of the Indian child parents and where appropriate the family, if the optimum services do not exist or are not available. Sometimes there might be a time frame that a parent has to complete a case plan by or a program by, and they miss the deadline, and so working with the parent to say like, okay, well, you missed the opening deadline for this one project or this one service. Let's find out a new way for you to access additional services in order to comply with your case plan. So thinking out of the box on those instances, and providing post-reunification services and monitoring. Instead of once the children are returned home, closing out the case and saying it's done, checking in on the family, providing them with supportive services, and making sure that the family can stay together and that there's no additional barriers that come up to prevent them from coming back as a case later on down the road. Okay, so after the review hearings, and if the review hearings fail and the parents are unable to complete their case plan, we might move on to the selection and implementation hearing and permanency planning for the child. There are many options to consider, especially for a child. Some of that might be return to parent and terminate the case, and family guardianship or family maintenance. There might be guardianship or adoption. Under the ICWA, there is no discussion of tribal customary adoption. That's something very specific to California. But under the ICWA, there is discussion about what must occur if an Indian child is going to be adopted. So if we move towards no return to the parent and adoption, the expert witness requirement kicks in again. So we're going to need a qualified expert witness to testify that make a finding or to testify that continued custody of the child in the parents' care will likely result in serious emotional or physical damage. And there, again, if there is a termination of parental rights petition or a request on the table, there must be evidence beyond a reasonable doubt that continued custody will likely result in serious emotional or physical damage to the child. At the selection and implementation hearing, there must be a reassessment of placement. So again, at the foster care placement, it was the extended family member, an Indian foster home, licensed by the tribe, Indian foster family, and a institution that has been that is run by the tribe of some sort. The placement preferences change when you move to adoptive placement preferences, and here we go. The first preference is a member of the extended family. Again, this doesn't say member of the extended Indian family. This is just extended family. Other members of the child's tribe. So if the child is, I think our other example was Cheyenne before, if a child is a member of the Cheyenne tribe, looking out to see if there are other members of the Cheyenne tribe who could take the child in. If there are no members of the child's tribe available, then the ICWA has a preference for other Indian families. Again, Indian means a member of a federally recognized Indian tribe under the Indian Child Welfare Act. There are some exceptions, and we can deviate from these placement preferences if there is showing of good cause. And that is on a case-by-case basis, but just know that these are 3 preferred preferences under the Indian Child Welfare Act. Again, there are some exceptions to termination of parental rights. Welfare and Institution Code 366.26 lists some of the exceptions, and one of them is, in the best interest of the child, the court may find a compelling reason not to terminate parental rights. And one of these compelling reasons may include that there is a substantial interference with the child's connection to the tribal community that would be caused by the termination of parental rights, or if the child's tribe has identified guardianship or long-term foster care with a fit relative. Some post-proceeding actions. So post-proceeding actions just mean that actions that are outside of the normal proceedings or past the review hearings and such. One of those key things are, one of the key provisions for post-proceeding actions include invalidation. And invalidation basically makes a showing that puts before the court that there was a violation of the Indian Child Welfare Act, specifically whether there was active efforts, inquiry or notice, or a violation of placement preferences. That can be a basis for an invalidation of the court proceedings. And invalidation proceedings can be brought by the child, the parent, the Indian custodian, or the tribe. And again, these proceedings must be made on a showing that there were violations of sections 1911, 1912, or 1913. And subsequent placements must be made in accordance with the Indian Child Welfare Act. So there's a little star here. We noted that an Indian custodian can file for invalidation, but the only time that the Indian custodian can do that is if the child has been removed from their custody. And that is the dependency case that's before the court at this moment. Okay, so very briefly, we just want to talk about non-minor dependents. And the Indian Child Welfare Act doesn't talk about non-minor dependents, but under California law, there is the Extended Foster Care Program, AB 12, which applies to 18 to 21 years old. And California law has extended the ICWA applicability to non-minor dependents, but it is fully dependent upon the non-minor dependent. If the 18 to 21-year-old agrees that they want the tribe to participate, then all rights under the Indian Child Welfare Act apply, which includes notice and access to the child's records, or the non-minor dependent's records. So if you have any more questions or you need more resources for understanding the ICWA as it relates in California, you can always look up the California Court's website. There you'll also find the mandatory forms from the Judicial Council as well. Always check out the California Department of Social Services for their Tribal Affairs link for more information and resources. The National Indian Law Library also has a lot of documents relating to state court cases and other information on ICWA as it pertains in California. And the National Indian Child Welfare Association always has some great resources for learning more about the ICWA. And if you have any questions, feel free to reach out to me. Again, I'm a staff attorney at California Indian Legal Services, and my email address is here below, mmirandi@calindian.org. Thank you for taking the time to watch this presentation, and we hope you learned something, and we hope to hear from you if you have any other questions. Have a good day. Thank you.